Chapter 29 talks about settlements in tort cases. Your role as a paralegal in a tort case is to gather information, monitor that information, and manage the case from the moment that the client walks into your office. Very often, your client will have already gathered some of that information, but a good part of your job is getting that information, getting it together, and making sure that it makes sense and presents a strong case. From the time that your client walks in the door, we are always thinking about, is this a case where we might be able to settle the claim? Settling a case is always preferable to taking it to trial. Taking a case to trial is absolutely a gamble because you never know what jury you are going to get. A settlement itself is truly just an agreement to resolve the dispute without going completely through a trial. A settlement can be simple negotiation between parties. It might be some form of alternative dispute resolution, but almost always it begins with the plaintiff making a request of the defendant to settle. That request in tort cases we call a settlement demand. The settlement demand is made by the plaintiff, to which the defendant may then respond with an offer. The terms demand and offer are terms of art that we use during settlement negotiations. Settlement negotiations can occur at any point in time during the litigation process. So from the time that your client walks into the door, settlement is something that you're already thinking about. Sometimes cases do settle very early. Those are the very strong cases. When cases need time to develop, very often we are waiting until our clients have reached a point where we understand what their final damages are going to be. And therefore, it may take a significant amount of time before we are ready to make a settlement demand. If you can imagine a typical negligence case where a plaintiff has been involved in a car accident with the defendant. The plaintiff comes to your office and explains to you the circumstances of the car accident. If the plaintiff has been scheduled for surgery 2 months from now, you have no idea what the damages are that the plaintiff has actually suffered. We know that there has been a breach of the defendant's duty, but we have no idea how much damage the defendant has caused. The defendant may at that point want to settle for $500, but we have no idea what the permanent damages to our client is going to be. Therefore, we have to wait until our client reaches a point, at least with personal injury cases, where they reach a point of maximum medical improvement so that we are then able to have a doctor give us an accurate prognosis as to what the actual damages are going to be in this case. It is not uncommon that that can take over a year, if not 2 years, to happen. Once the case has been determined to be ripe for a settlement, typically what your job as a paralegal is going to be is to gather the information and put together a package of information to advocate for your client to the defendant. You are advocating for a certain dollar amount that has been decided upon with the party, with the plaintiff in this case, under the advice of the attorney. Determining the dollar amount that a case should settle for is definitely an exercise in art, not science. There is not one formula that we use in order to determine what the damages in any particular case is. You will hear rumors running around that the damages in any particular case is always 3 times the medical bills. I have no idea where that rumor started, but that is not true. Instead, you as a paralegal may be asked to do research as to what are juries in this jurisdiction awarding for cases similar to our case. This research can be found in subscriptions, or it may be found through different organizations that your law firm will belong to. This research should also include conversations with your attorney as to what their experience has been and what their predictions are regarding the success of this case. Do not hesitate to share your observations of the case and observations of the case's strengths and weaknesses as you see them. Once you and your attorney have talked about this, the attorney will talk with the client to make sure that the client is comfortable with the dollar amount that is being requested. Typically, I will get a range from my client, so if I am going to try to get, in my mind, $100,000, I might ask the client for authority to settle somewhere between $80,000 and $100,000. This way, I have some flexibility in terms of what I can negotiate for, but also I have my client's authorization to be able to settle within a reasonable amount of what I predict is a realistic amount of money. Of course, when we begin to negotiate with the opposing party, we do not start from where we have our authorization. Just like if you're negotiating to buy a car, we always start a little bit higher than where we want to go. So if I'm trying to negotiate with a defendant to try to get $100,000, I might start somewhere between $130,000 to $140,000, knowing that I can come down from there. Much of what your job will be if you go to work in a firm that does a lot of personal injury or tort cases will be that you will be preparing settlement packages in order to present to the defendant to try to settle the claim. These are typically letters that will be sent to the opposing party with attached information such as a list of medical bills or perhaps a police report or supporting evidence. There are basically two approaches to trying to settle a case. One is a very complex approach. This is called a settlement brochure. A settlement brochure has extensive amounts of information contained in it showing what the damages are and the extent of the damages to the plaintiff. Your book has an example of a settlement brochure starting on page 630. The settlement brochure, as you can see, has several pages of information that has been written by the plaintiff's law firm explaining the case and why the law firm thinks that the case is worth a set amount of money. You can see on page 2 of the settlement brochure there's a table of contents. That table of contents has extensive amounts of information. Total number of pages is 42 pages. This is definitely a settlement brochure. Many settlement demand letters that you will be writing will only be 2 or 3 pages in length. But with the settlement brochure, as you look through it, you will see there are many attachments. There are the full reports from doctors. There are full reports from physical therapists, from a social service agency, all of these supporting the amount claimed in damages to the plaintiff. Settlement brochures are typically used in high-dollar cases. I equate this to when you go to sell your home. If you live in a $5 million home, your open house probably has several real estate agents. They have a reception, they have food, they have people talking to you. There's probably a full-blown video describing the home. Whereas if you live and you're selling a $50,000 home, you probably have a page on a website and a sign out in your yard. When we're asking for a high dollar amount, you have to be able to justify the dollar amount that you're asking for. We justify this with a larger amount of evidence supporting our claim for that higher dollar figure. Smaller cases, we typically will simply send a settlement letter, or as the book refers to it, a settlement precis. A settlement letter is one that contains much of the same information, but is on a much smaller scale. The settlement letter typically is going to be 2 to 3 pages long and still is sent to the defendant as a settlement demand. You still may include some reports, you may still include some pictures, but it's not the depth of information that's contained in a settlement brochure. Between the two of them, it really just depends on the amount of information that is necessary to support the amount of money that you are claiming. They both contain the same basic framework. One, the settlement brochure, contains much more information. The other, the settlement letter, is much more basic information. So let's take a look at what is contained in a settlement demand letter. You will be getting a set of facts and some memos taken from a client that gives you the background of a case. This is going to be a basic dog bite case where a dog has bitten the face of a person who is claiming damages. All of those documents will be posted on Blackboard for you to review, so you have the basic information behind the case. We represent the plaintiff because the settlement demand typically comes from the plaintiff. A sample settlement letter can be found on page 627, 628, and 629 in your books. The settlement letter or settlement precis has some basic elements to it. You want to be able to identify the plaintiff. You have to give the facts of the case. You need to present your theory of liability, include any medical reports or any medical support that you have. You need to give a list of the medical expenses or other damages that the plaintiff has incurred. And then finally, you give your analysis of the case. That's where you say how much you are demanding for settlement. If you look in your books on page 627, I'll take you through each one of these to give you an idea as to what I expect in your settlement demand letter. First, let me say I expect your settlement demand letters to be 2, maybe 3 pages long. If you are going longer than 3 pages, it's too long. So keep that in mind. Most people will at least have 2 pages. 3 pages is truly the maximum for this assignment. When we're identifying the plaintiff, keep in mind that a settlement letter is absolutely an advocate. You're arguing for your client. So you need to be an advocate for your client. If we have a car accident, we don't say that this is a car accident. We say that this is a car crash. We use words, and we go through and we wordsmith each and every phrase that we use to make sure that we are arguing to the fullest for our client. We are not taking an objective point of view here. We are arguing and trying to make sure that we put our client's best foot forward and convince the defendant that this is a case they should take seriously and should pay us money for. When we're asking for money from a defendant, they need to be explained what's going to happen and what type of case that we have so that they're willing to step up and pay money. So the first thing that we do is we identify who the plaintiff is. Now, don't go and say, this is, this is Mrs. Robinson, she's, and you go through and just give her vital statistics. Instead, you want to make them a real person. What is good about them? If I had my perfect plaintiff, maybe they'd be a little Boy Scout and they, donate their time and all these good things about people that we like about people. Those are the things you want to bring out about your client, the plaintiff. You may want to give their social history. You certainly want to give their medical history. Now, hopefully, the medical history is they've never had any problems like this before. Sometimes they do, sometimes they don't. It just depends on who your client is going to be. Then we want to give the facts of the case. The facts of the case are still a time where we are advocating for our client. Do not feel like you are restricted only to give me just the facts. I want you to explain the facts in a way such that you are making the case for the defendant to hear things from your client's point of view. This is not the time to be objective. You've got to be explaining to the defendant your version of the facts. Don't worry about being able to adequately represent the defendant. You don't represent the defendant in a settlement demand letter. You only represent your client. This is not where we're advocating to the court, where we have to abide by the laws of candor to the court. This is completely biased. Now, with that said, don't go too far overboard. We all know where the sale gets too hard and we go, really, and you don't believe it. Make sure that you are comfortable in the amount of advocacy that you have, but do not fall back on being completely objective when you state the facts. Also, when you state the facts of the case, please do not just reiterate the information that I have given you. Too often I have it just copied and pasted back to me. That is not what I'm looking for. I'm looking for you to present the facts in a light most favorable to the plaintiff. The next section is theories of recovery. Under theories of recovery, this is where we say, what is our cause of action? You should list the elements to your cause of action and then list the facts or analyze the facts that support your cause of action. Again, all using advocacy and trying to argue in favor of the plaintiff. The book has some case law in there, I think even some statutes somewhere in here. Do not worry about citing any case law. Do not worry about citing any statutes. This is a negligence case. We all know the elements to negligence. You can use the information contained in the book, but I do not expect you to go through and cite any type of case law. The next section is medical records. Medical records or reports will help support the damages in any particular tort claim that involves personal injury. Medical records are the records that doctors and hospitals keep during the treatment of a patient. A medical report is something that we separately ask for from the doctor that they generate only because we asked them to. A medical report typically has a prognosis in it. It has doctors' opinions in it, not just their observations. In this particular case, you want to go through and look at the information that you have. Again, I will provide you that information. Look at that information. Give an idea as to what the damages are. Now, again, how do you advocate where there's medical records? Well, for instance, when a doctor says there's a contusion, you may want to say there was a severe bruise, it was black and blue, and she was swollen. Don't use the cleaned up, sanitized version of medical treatment. Use words that make it sound like it hurt. That's what happened to your client, and it hurt. Make sure that you are conveying that through the words that you use. Again, avoid the overdramatic use, but certainly make sure you're advocating. The expenses section on page 629 is a pretty good example of what you would be doing. You want to go through and justify the amount of medical expenses or any expenses that you are asking for. So you would go through and you would list all of the medical bills. You would list any incidental damages that the client has incurred. And you also want to include any future damages that the client has incurred. If you're asking for pain and suffering, both past and future pain and suffering, you can go ahead and include that here. If you choose to, you can simply include that in the total dollar amount that you're asking for, just as they did here in this example in the book. The last section is analysis of evaluation. And this is where you are putting forth the total dollar amount that your client is willing to accept for settlement of this case. In this example, they say that they think a jury verdict could fall somewhere between $100,000 and $125,000. You can put that in there if that's what if you do look up any jury verdict information, and by the way, you're not required to. But if you find some information that gives you an idea as to how much it may be, You can put that in there. We do not cite any information. We just kind of put that forward. If you have a case that you want to cite and say, a case that was recently in the news came down for $2 million. Okay, but that's not typically what we would do in that. The last thing that we do is we do finally say that we are willing to accept a settlement in this matter for a total amount, and you put the total amount of money there. Remember, this is a letter. It goes on letterhead, and it has a letter closing, so it would be something like very truly yours. Very truly yours. Go ahead and use my name, Paige Beadham. If you need a sample letterhead, I will post one under course documents so that you have that letterhead. And that's it. That makes it sound like, oh, it's just a few paragraphs. A lot goes into those few paragraphs. This is the work of what you will be doing and working with your client with for over months, if not years, of the time that they are with your office. But all of this is then sent to the defense attorney. The defense attorney then will either respond saying, yes, of course I'll pay you the $80,000, or very often they'll start to negotiate from there. That's pretty typical. For your assignment, you are going to be creating a settlement demand letter in the Robinson versus Adcock case. I will post all of the factual information on Blackboard. We will have the next several weeks to be working on this settlement demand letter. You are welcome to get if I were to be starting this now, I would be reading the information on Blackboard. I would get a framework for the letter. All that has to look like is letterhead with a closing, which is the very truly yours, Paige Beadham, and then put some headings in there. So your headings are going to be the headings just listed here on this slide: identity of the plaintiff, facts of the case, theory of liability, medical reports, expenses, and analysis, just like it's set up in the book. Once you get a better understanding as to the facts of the case, and then you start looking through the facts of the case, you can start sliding information into those different categories. But if you come to class next week and you have just those categories and that framework and an understanding of the facts, you'll be in good shape, and we'll talk a little bit more about where to go from there on your settlement demand. If you have any questions, feel free to give me an email. I will not have access to email on Saturday or Sunday this weekend, but I will have access the rest of the week. So please feel free to give me an email with any questions that you have. This is not due for almost another month, so feel very comfortable in that. You've got until May 23rd, I think, to have this completed. We will have time to go over this in class and to go over any questions. Have a good week, and I will see you next Wednesday.